Hey guys, and welcome to today's video. Today, we have a slurry of mental rejects, all making special appearances on their own behalf. We have a sovereign citizen in Judge Perkins' courtroom, a fifth-year sophomore in law school who knows everything about everything, and finally, a Karen and Kevin married couple to end all of it off. We're going to start with the soft sit in Judge Perkins' courtroom, as this is the conclusion to a case that I've been following for a while. So let's begin.
City of Detroit versus Contrell Grigsby, case number SP 1683392. SP 1683393, counts 1 and counts 2. Appearance on the record, please. For the record, please. Mr. Grigsby.
That's Barry Jr.
I don't believe that's Mr. Berry, I don't believe that's necessary. I don't know, Mr. Grigsby, do you want representation or no?
No, sir.
State your name for the record, please.
Special appearance, Contrell Grigsby.
Okay, good morning to you, sir. Today is the day and time set for a final pretrial. Set for a jury trial tomorrow.
Can I ask a question?
You may.
Since the last time we spoke, you told me to just bring all my paperwork down there. I wanted to see that you received it. I had brought it down to the courtroom.
I don't really know if it's going to be necessary. I also told everybody that all parties need to appear, and as their whole Valenstein is here. So no, I didn't get any of your paperwork that I have at the moment. Do you have Contrell Grigsby? No. And what should I expect to see in that or read in that paperwork?
Should I brought my fee schedule down there. I brought me an affidavit, conditional acceptance, and I brought a few things down there.
So let me get this straight. You brought your conditional acceptance and your fee schedule? Well, while you're at it, why don't you go ahead and attach your doctor's note from the loony bin? Because you must be crazy if you think that we, the people, are going to pay for your stupidity.
I had last time we talked, you had gave me a lady's email address, and I also sent all the paperwork to her email address.
That's probably court. Officer Valenstein, good morning to you. Can you, we're on the record with Mr. Grigsby. Can you state your name, department and badge number, please?
Yes, good morning, Your Honor. Officer Valenstein, Detroit Police Department, badge number 4744.
All right, very well. Today is the date and time set for a final pretrial. So we do have all the parties here. There's going to be a jury trial tomorrow. I'm imagining that trial is going to go. I would like to have Ms. Schneider here to make sure that you two agree on any jury instructions. I don't know if you've made any, if you've gone over any jury instructions and have an agreement on the jury instructions and things like that, or we'll just read the instructions as they are listed in the, if you have not. So I'm going to wait until Ms. Schneider comes in. Mr. Grigsby, I'm going to put you in a breakout room with Ms. Schneider. You two can have that discussion, and then we'll get you out of here. I'll wait till she comes back. We'll get you out of here after you talk to Ms. Schneider about how you two are going to proceed, all right?
Okay, cool. Yes, sir.
All right, so outside of the fee schedule, nothing too much to note. At this point, the prosecutor comes back and they go into a breakout room to discuss his upcoming jury trial.
Let's go back on the record with Mr. Grigsby. Ms. Snyder, can you put your appearance on the record, please?
Morning, Your Honor. Alexa Schneider for the people, P80322. The issuing officer is present.
Yes, I've already spoken with him. So have you and Mr. Grigsby spoke about procedure tomorrow?
Yes, Your Honor, we did discuss it. I sent you a chat. Mr. Grigsby has not prepared jury instructions, but he does have a civil infraction along with his misdemeanors. I talked to the officer. We're going to dismiss the 2 misdemeanors. He can proceed with a formal hearing on his civil infraction.
We're not going to call a jury in for that.
Correct.
What about right now? Mr. Grigsby?
Yes, sir.
So you can either pay the 145 and then we'll close it out, or you can have a formal hearing on that. The officer's here right now on the expired.
I'm having I want to have a formal hearing for Mr. Grigsby.
All right, are you ready to proceed now, Officer Valenstein?
Yes, Your Honor.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
Yes, sir.
All right, it's on you, Officer Valenstein. You want to assist Ms. Snyder or not? I guess not.
Yes, I'm
I'll
all
leave
for
it
it.
to you, Your Honor.
Say that again.
I'm sorry, I cut out. What was that, Miss?
I was going to say I'll leave it to his honor.
Oh, okay.
It's up to you two. I mean, it's a civil infraction of expired plates. Go ahead, officer.
Okay. Back on February 19th, 2025 at approximately 6:29 p.m. I was doing traffic enforcement in the area of Grand River and West Grand Boulevard. I seen the silver Chevy driving southbound on Grand River. I did a traffic stop, or I ran the plate, came back that it was expired. Back on December 21st of 2024, pulled the vehicle over, conducted a traffic stop. The driver, Mr. Control Grigsby, stated that, there was no registration for the vehicle.
So you're saying that he admitted that there was no registration for the vehicle?
As far as I recall, yes. There was no registration to show. I mean, as far as everything else, I don't know if you want me to keep going about the insurance or the displayed license, but.
No, I don't think that's relevant now, because that's going to be. So basically, on this date and time, you pulled the vehicle over, and the vehicle, for your testimony, the vehicle did not have valid registration, and that you're saying that Mr. Grigsby told you that the vehicle did not have valid registration.
Your right to remain silent extends beyond the courtroom and is clearly your best weapon when fighting traffic charges in court.
Go ahead, Mr. Grigsby, if you want to say more.
Yes, according to
Let me swear you in. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth? Raise your right hand, please.
I want to.
Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
As long as I'm not giving up any of my my rights.
No, you're not giving. You're just swearing to tell the truth, whole truth, and nothing but the truth.
Okay, cool.
Say yes or no.
And as long as y'all know I'm in special appearance, yes.
Do you swear or affirm to tell the truth, whole truth, or nothing but the truth?
Yes, sir.
Okay, go ahead.
Yes, sir. According to Michigan law, I'm only supposed to have my license or anything, license, registration, or insurance if I'm doing commerce, and I'm not doing anything. I was just traveling. I wasn't as I told the officer I was traveling. I'm only supposed to have a driver's license if I'm like making money or doing anything. I wasn't in, like I told him. Same thing I'm telling you.
So you're not disputing the fact that you're not disputing the fact that you didn't have plates on the vehicle, proper registration for the vehicle?
I'm disputing the
I'm
fact.
asking you a question. I'm asking you a yes or no question.
I'm asking you a question that is.
No, you don't ask questions. I ask the questions.
Well,
So, is it?
Mr. Owens, the mutual device, please.
Did you tell the officer that you didn't have any plates on the vehicle?
I don't recall what I told the officer.
Okay, well, he seems to recall very well. Is there anything further?
Yes,
Go ahead.
Michigan code. As I sent to you, I brung down there and I emailed the lady. Michigan code says that I do not need to register my vehicle. I do not need to have a license unless I'm acting in commerce. And I was not acting in commerce as I told the officer plenty of times. I'm not acting in commerce, so I don't need a license or I don't need to register anything.
All right.
Michigan.
Is that it?
Oh no. And I sent you my conditional acceptance twice. I sent you all of my paperwork.
I'll let you put it on the record. So I'll let you put it on the record. Is that it?
Yeah, I want to put all my paperwork on the record. Did you receive it?
No, I told you I didn't.
Well, I don't know how. I got the
in this case, I'm gonna tell you this, I don't have to. Find you responsible, $145. When can you pay?
I'm not paying it.
Of course you're not. Because why would you be a positively contributing member of society who takes responsibility for his actions when it's easier to be a societal trash bag who can't be bothered to be held accountable for his actions? But you know what? Don't pay. Because you'll just end up having it on your credit, and there'll be a day when you want to act like an actual adult with the rest of us, but you won't be able to because you won't be able to get a license until you do pay it. Now the hearing is over, but the Saw Sit had something smart to say to Judge Perkins.
All right, bye. Have a great day, sir.
Yeah, y'all will be hearing from me. You'll be hearing from me, boy.
$145.
It is.
I'm not your boy, all right?
You want to be.
I'm not your boy, okay? So don't say too much more, sir. I'm just saying you're free to leave. Have a very good day.
All right, so that's the end of that mess. And while I hope the soft-tard will get his shit together, the truth of the matter is, just like the rest of them, he'll be back. Now we head to Judge Boyd's courtroom, where we have a fifth-year civil law school sophomore who thinks he can represent himself in a criminal matter.
You always dress appropriately for court. I appreciate that. No, that's good. All right, so what's going to end up happening? We're currently in a jury trial, so I can't do jury trials at once. I've done that before, but the staff is like, Stephanie, it's too much.
Yeah.
So what's going to end up happening is your case is going to be recalled for another trial setting. And you have a choice. You can have a jury trial or you can have a bench trial. Jury trial, 12 people will hear the evidence and they'll make a decision on whether you're guilty or not guilty, or you can have a bench trial.
Okay.
A bench trial is where I hear all the evidence and I make a decision. What I can tell you, if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't prove their case beyond a reasonable doubt, I'm going to find you not guilty. So that's something for you to think about between now and your next court date, okay?
Okay.
All right, so let me do this first. We're going to go on the record. Court is calling 2024 CR 009936, State versus Carrie Lampkin. Are you Carrie Lampkin?
Yes, sir.
All right, could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand if you'll state your name for the record.
Carrie Lampkin.
All right, I'm going to ask you some questions, and the questions, thank you. The questions that I'm going to ask you are related to your representation. It's not about the facts of the case. If it were about the facts of the case, then the state would need to be here. This is just a determination of whether or not I find that you should be allowed to represent yourself, okay?
Okay, it's like qualique.
Hmm?
This is a qualique.
A what?
Qualique to see if I'm able to represent myself.
Yes.
Okay.
All right. So how far did you go in school?
I'm currently in school right now. Should be graduating next year, but now that I've been I'm now getting behind with finals because of,
All right, so here's the thing. The best thing about being a witness and what attorneys always tell witnesses is just answer the question that's asked of you.
okay.
So, how far are you in school?
I'm in college now.
All right, what year?
I'm considered a sophomore/junior.
All right, and what are you studying?
Law.
All right, and how many years have you studied the law?
I'll say about 5 years.
You clearly didn't pay attention to your first 3 freshman years when they most definitely taught you that when you represent yourself, you have a fool for a client. But to be honest, after hearing what he says next, I'm not so convinced that he even has 1 year of legal education.
All right.
But it was in the civil litigation and family law. And
So have you ever studied criminal law?
I never had a desire to learn about it until now that I'm going through this.
All right, so remember what I said, just answer the questions. Have you ever studied criminal law?
I've never studied criminal law, but based on my study, it's like all civil in nature.
All right, so here's my other question for you. Do you understand you have a right, because this is a criminal matter, you have a right to have an attorney appointed to you if you cannot afford to hire an attorney. Do you understand?
Yes, ma'am.
All right, so do you want to have one? Can you afford an attorney?
Well, at
That's
the moment,
yes or no?
At the moment, no, because of
All right, then the
I
next
think-
question, here's the thing, just listen to the questions, all right? Are you able to afford to hire an attorney?
no.
All right. Would you like an attorney appointed to you? That's either yes or no.
But I'd be able to speak to counsel, like someone from my counsel, to be able to make a decision. I don't want to just rush and say yes and no when I don't.
No, I mean, here's the thing. You don't get a chance to choose who your attorney is.
Yes.
My question for you is, and I just want you to answer my questions.
Yes, ma'am.
Would you like to have an attorney appointed to represent you? That's either yes or no.
Your Honor, I'm sorry. I'm like, I just feel like I'm being pressured and rushed, and I don't.
No, you're
wanna
not being
make
rushed.
that
This case has
decision
been
right.
going on since January 2025. Let me explain something to you. When this case comes to trial, it is going to trial.
Yes, ma'am.
There's not going to be at the last minute, I decided I don't want to do this. Let me get an attorney and get another reset. That's not going to happen. So my question to you is, do you want an attorney appointed to you? That's either yes or no. If your answer is no, whatever ends up happening, you end up representing yourself, then you're going to represent yourself. I'm not going to give any resets because in the middle of trial, you decide you're over your head and you need an attorney. That's not going to happen.
Your Honor, with all due respect, my attorney, I had.
Here's the thing, don't start with,
Yes, ma'am.
with all due respect. And let me just tell you why.
I'm
No, no, no.
honorable and-
This is what I want to tell you. When people say with all due respect, they're really getting upset. And usually what comes after with all due respect is not with respect. It's like when people say, let me be honest with you. Usually what's coming is not honesty.
I'm so sorry. I wasn't trying to go that route.
No problem.
I was just wanted to say with all respect, Your Honor.
Well, with no due respect, you should probably just shut up and take the free attorney, especially since you've just admitted that you have absolutely zero real experience in criminal lawyering, and you just showed that you have zero idea of what's actually going on in the courtroom.
The reason why I withdrew from my attorney, there was an issue with discovery since day one when I
Okay,
hired
here's
you.
the thing. I don't get into things about you and attorneys and what happened with your previous attorney unless your previous attorney is here to
Understand.
give their side of things.
Yes. So, like again, Your Honor, so I'm not afforded my due process rights. I don't know. It's like, to me, it's like you're making a judicial decision, and I don't.
It's not. It's either you want an attorney to represent you and afford one.
I'm asking you nicely, Your Honor, if I could have some time to make that decision. Because I don't want to make the right decision if I'm going to defend myself. I'm already lack of discovery.
My answer to you is no.
Yes.
If you want an attorney appointed to represent you, that attorney is going to be appointed today. You're going to meet them today. If you don't want an attorney appointed to you, then one will not be appointed to you. And your next setting is going to be a jury trial. And when you come in, it's going to trial. That's where we are. And I'm going to tell you again, previously, when you were saying you were filing your bill of particulars, I am not going to be an attorney for you. I'm not going to show you how things legally should be done or the legal process, because the last time you were here, I was helping you with your motion to say, is this what you mean? I'm not going to do that anymore. I'm just going to look at your motion. And if your motion is not in the proper order, if your motion is not asking for appropriate things, it's just going to be denied. So it's not going to be my job to walk you through questioning of witnesses. I'm assuming if this goes to trial, the state is going to call witnesses.
Okay.
Not going to be my job to help you cross-examine them. It's not going to be my job to teach you the rules of evidence or criminal procedure. That's going to be all on you. And if you're not following those rules and the state objects, and it is an appropriate objection, then it's going to be sustained.
Yeah, I'm
So-
not asking for any legal advice or.
You have been, though, because the motions that you've been filing have not been appropriate motions. Your bill of particulars, when I read it, it's really not a bill of particulars. What it is a request for a pretrial hearing on certain matters. This is going to be going.
Be respectful as possible, Your Honor, but
No.
you're applying pressure on me to make a decision, and everything is moving fastly. Like, I don't consent to go to jury when my due process has been violated.
There you go again, saying stupid shit. You're literally in the middle of your trial now, so your due process hasn't been violated because no one's disposed of your criminal allegations yet.
I'm praying that you can hear me out, but it seems like you're pushing me into making a decision without.
No, so let me just explain something to you. Your attorney was here at the last hearing. Your attorney said that he's already shown you all discovery and you received that. And here's the thing, you're saying that's not true.
I have substantiated evidence, Your Honor.
But listen to me, put on your listening ears.
Yes, ma'am.
This is what I'm telling you. Your attorney, the attorney that you hired.
I didn't hire him.
Your attorney.
I didn't hire him.
Your attorney said that they gave you all the discovery. Sometimes people receive discovery and they don't like what they're seeing. That's fine. That attorney is a good attorney. That attorney has not had any violations, no ethical concerns by this court or by the state bar. That attorney said that you had already received all of the discovery. That attorney even has a portal on his website where his clients can go in and look at the discovery that he's received. He said that you've already received that. So you're coming to me saying that you haven't received discovery. Your attorney says you have.
Yeah.
So, nope, let me stop you there. So what I am telling you is this is going to trial and you're standing before me saying that you have not received discovery when your defense attorney says, I have given you the discovery and I have no reason to disbelieve your attorney. Your attorney has never given this court any reason to disbelieve him when he says that you have received discovery. Their question, and this is the last time I'm going to ask it, and you can answer it. If you don't want to answer it, that's fine. This case has been on the docket since January. What I am telling you right now is you will answer yes or no. If you don't want to answer it, you don't have to answer it. Do you want an attorney appointed to you? Yes or no?
Under pressure, I don't understand.
All right, that'll be no.
You know, you really missed your calling as a failed politician, as they're much better at not answering questions than lawyers are, and you can't seem to answer a simple yes or no as to whether you even want another attorney appointed to you or not. So Judge Boyd has answered that question for you.
Ms. Ferguson, place this on the jury trial with Judge Angelini on June 16th.
So I'm not able to talk, Your Honor.
Sure, you can talk. Go ahead.
So I have placed on the record, Your Honor, substantiating evidence of the proof that I have not been able to receive discovery. On May the 3rd, I have received the email of some more discovery that my attorney sent me after I filed a motion to withdraw from him. The only reason why I filed this motion to withdraw from him is because of the lack of discovery since day one. You know, Your Honor, every time we came here, it was, oh, Your Honor, the file's too big. Oh, Your Honor, I don't have, I haven't got it from Jason. Oh, Your Honor, he has to come in and buy a hard drive. Like, he made me as his client get a hard drive to go get it, and he still didn't give it to me in a hard drive. Your Honor, I have substantiating evidence to prove my facts, and I have submitted it. I have filed it in the clerk with the clerk. So if he's willing to say what he said to you in court, that he sent me discovery, I would love, Your Honor, if he could do a sworn affidavit statement stating what he said, so it could be put into.
He's an
evidence.
officer of the court, so he doesn't have to do a sworn
Yes,
affidavit.
I understand, but I put the burden of proof. I showed the burden of proof, Your Honor, of my facts. I'm showing you that I did not receive discovery until Saturday, 2 days before trial, 2 days before court date hearing. If you can look in the system, you'll see an affidavit statement signed by a notary that I signed under perjury, under sworn, I swore in, and I under perjury. I'm not trying to go to jail over lying. I'm telling the truth, Your Honor. He did not give me discovery until it was a Saturday, that Saturday before court.
Yeah, but he was your lawyer, so he would be the one that's litigating your case, not you. And he may think that you're a loudmouth idiot who thinks he knows everything about everything, and giving you the discovery will only make defending your case even harder for him. Not to mention, under Article 39.14 of the Texas Code of Criminal Procedure, a defense attorney may allow his client to view the discovery, but is not required to. And also in that article, it specifically states that your defense attorney cannot provide you copies of the discovery. But now that you're representing yourself, you can receive the discovery. So Judge Boyd is going to call down the prosecutor so you can get the discovery and go play Perry Mason in the corner by yourself.
And it's big. It's a big file. And how could you miss that? Yes, he did send some before, but he's piecemealed, Your Honor. 1 month, 2 months out, 2 weeks after that, in 1 month after that. It's like he's been piecemealing this stuff to me. And then he says that, oh, the file's too big. And this would make me make the decision to withdraw from counsel because he's not the best fit for me. Maybe he's a good attorney, but he's not probably the good fit for me. And this would make me want to represent myself because I wanted an attorney. But after I went through 6 months with dealing with him, and I was very patient, very patient. I didn't say a word. I didn't get upset with him. He wanted me to take a plea deal before I even got discovery. And that's what really made me not upset, but made me a little concerned because I'm like, you're representing me, but you want me to take a plea deal without me having discovery? Like, where's my due process rights?
Mhm.
You know, that's a violation of my due process rights. I need to be able to defend myself. I cannot defend myself properly if I don't have all the evidence in front of me.
Mhm.
That's all I've been trying to say.
Your acknowledgement of discovery was signed, that discovery was received on April 14th. Ms. Ferguson, could you have somebody from the state come down, please? And if you'll give him a reset form for June 16th.
So, Your Honor, you denying the fact that we have to go into jury without my due process for the record? I just want to know, Your Honor,
Oh.
for the record.
For the record. Hello. Hi. So Mr. Lampkin is here,
Okay,
and he's saying that he has not seen any discovery.
that's not.
So-
correct. I already talked to Cornelius Marshall, I mean.
Yes,
He went over to him.
yes. So if you have the state's file, if you can let Mr. Lampkin see that. All right. Deputy Mejia, if you have him sit at the defense table.
So you know, I do have a work product, but it's not really work product, I'm gonna set that up.
All right.
What is this again?
You can look at it.
Okay, Your Honor, I say we're on the record.
Oh, we can be on the record.
Yes, I would love to be on the record. Anything we do in this proceedings, I would love to be on the record.
Oh, sure. We're back on the record in 2024 CR 009936. State versus Carrie Lampkin. Yes.
Okay, Your Honor, you just mentioned that he said that I received it. He's saying that I received the discovery. Jason? I received this.
Incorrect. I didn't say you received discovery. I said that this marshal, your attorney, well, that you hired.
Yes, sir.
At that point, had received it and said on the record that he had shown it to you. That's what I said.
Okay, yes, sir. Just clarifying for clarification. Your Honor,
Here's the thing, what I want you to do is look at the discovery.
Yes, ma'am.
There it is.
okay.
Thank you. And he's coming back for jury trial on June 16th.
June 16th.
Yes.
All right, so it looks like we won't be seeing this guy for a few more days. And I don't really know where that other judge's courtroom can be viewed, but I'll do my best to find it. And if it's any good, I'll bring it directly to you. So now we head to our final hearing, which is a married Karen and Kevin trying to sue some yacht club for what can only be described as rich people problems.
Hazel Isaacson and Ed Stolarik. It's case number 39092. And all right, so Ms. Isaacson, we have you, and Mr. Berner is here. Apparently on behalf of Mr. Stolarik. So let me ask this question. I didn't see service in that matter. Do we have service?
Yes, Your Honor.
Ms. Isaacson, did you serve Mr. Stolarik with this
Yes, Your Honor.
documentation?
I served both through the mail. I have the receipt, and I also served through the Secretary of State. And I have both
Did you
proof.
file any of that service documentation with the court?
Okay. And just file it with the court?
So you haven't filed it yet with the court. Is that what you're saying?
That's correct. I have it right here.
All right. And let me ask you this question. Why did you serve Mr. Stolarik?
Because Mr. Stolarik is the individual who was in communication with us and was the decision maker for that we needed to remove things and telling us that we were owing money, and also who was putting our boathouse up for sale. He was the individual in charge. To my knowledge, he was the person who was in contact with the Board of Trustees.
All right, Mr. Berner, I'll hear from you just as to the preliminaries of the case.
Thank you, Your Honor. Mr. Stolarik is a board member of the Olympia Yacht Club, but he's not the registered agent. The service of the notice of small claim was provided to the Olympia Yacht Club via certified mail, but it was for the hearing that was previously set for March 21st, 2025. I had to call the court to see if there was another hearing, so that's why I'm here today. So service was not effective on the yacht club of the notice of small claim. And then, as Ms. Isaacson mentioned, this is a dispute over a boathouse, which is titled property. It's titled in the Isaacsons currently. It's tax assessed. It has a parcel number. So district court does not have jurisdiction under RCW 3.66.030. I have also tried to contact the Isaacsons via mail and phone calls, but they haven't returned my calls. I represent the Olympia Yacht Club. I've reached out to them multiple times, so be happy to talk with them, but I don't believe this matter is right to proceed today.
And he's correct. RCW 3.66.030-1 clearly states that this court doesn't have jurisdiction over claims involving titled real property. And this claim involves a titled property, so it's not proper to hear it before a court with limited jurisdiction. Not to mention, they're bringing this case against a member of the board and not the yacht club board itself, so the claim wasn't even properly served upon the proper party.
Your Honor, may I speak to that?
In a moment, let me ask this question. Has the sale of this boathouse actually occurred or not?
I have no knowledge. I have no access to the boathouse. They have the keys.
All right, I'm asking Mr. Berner.
Oh, I'm sorry.
It has not. Still titled in the Isaacsons' name.
All right, Ms. Isaacson, go ahead.
In November of last year, I hired Joel Peñar to help us try to mediate this situation. And this is the attorney that we were speaking to, so he's well aware of what's been going on. He also was informed by Joel. I informed the court last time we were here that this is the attorney who was informed about this small claims court, yet they didn't show up the last time, even though I had tried to get service 28 different times through a service company. I did get service finally through the Secretary of State, and Mr. Peñar had suggested I go through small claims in order to try and expedite this, because there was this attorney keeps increasing both the funds we owe, and there's no it doesn't even make sense what this attorney wants. So I can't move. I can't have access to the property. I can't make any moves until something is done. Even though the property's in my name, I have no access to it.
All right. Two problems, Ms. Isaacson, with this. Okay. First of all, your claim is for money damages here. You're claiming that at least as I read it, that the boathouse was sold for $25,000 and you're wanting some portion of that returned to you. Mr. Stolarik did not sell that property. He didn't have title to do that. So you're making him the defendant in this case, even though he may have spoken to you about this and so forth. He's not the proper party defendant in this case. Looks like it's the Yacht Club that's the appropriate party defendant in this case. So that's number one issue, that there's not been proper service on the Yacht Club, even though Mr. Berner is here on behalf of the Yacht Club today. Second issue is, what's the jurisdiction of this court in relation to the property that you're talking about? Mr. Berner makes a good point that this court only has limited jurisdiction in this matter, and for property that is owned with the title in this way, real property, so to speak, this court does not have jurisdiction in that matter. And he quoted the RCW that deals with that. It's RCW 3.66.030. Now, I can't, as the judge in this case, I can't decide to give you legal advice as to how to proceed with this thing further. But what I'm obliged to do at this point is to say that this court doesn't have jurisdiction in this matter for two reasons. Really, number one, the wrong party defendant is listed here. Mr. Stolarik is not the proper party defendant. And number two, this court doesn't have jurisdiction over this kind of case, so to speak, when you're talking about real property or what is considered real property. So I am going to have to agree with Mr. Berner to dismiss this case. Go ahead, Ms. Isaacson.
May I ask a question? I sued Mr. Stolarik on behalf of the Olympia Yacht Club. He is a board member of the trustees and would be responsible for decision-making of the club. And he did not show up. He just sent an attorney. That doesn't seem like it's proper within the court, but I don't say there's no attorneys that should be present in the court.
What did you expect? The entire Yacht Club to show up? The Yacht Club is clearly a corporation or business of some sort, and they have a registered agent to receive service and an attorney that represents them in legal matters. So if you want to sue the Yacht Club, you need to serve the right person and expect a legal representative to represent them in court.
In addition, it's not just a complete where we own the property. According to the Olympia Yacht Club, they lease it from the state of Washington. They lease the property, and then we purchase the property through them And we only have access through because they allow us to have access. So I don't understand if they have a lease, but we buy the property, what jurisdiction it would be under, because they're leasing through the state of Washington, and they're not following some of the rules of the state of Washington. So wouldn't it be this court that I could go through? Your Honor, my husband is available to help me. He's not an attorney, but he did go to law school and he's ill, but I can bring him in to maybe help clarify some of the things about our club. He is the part owner.
Here's the
I'm a little
problem.
overwhelmed by the attorney.
Thanks, Your Honor.
Here's the problem, Ms. Isaacson.
Wait.
Mr. Stolaric is, as I say, not the proper party defendant in this case.
Your Honor,
He may be on the board of directors, but he didn't sell the property. He doesn't have the money. The property hasn't been sold. Much of what you're arguing about here in this case, hold on. Much of what you're arguing about here hasn't occurred yet. It hasn't been sold. And you're asking for money from from a transaction that has not occurred. We're getting far afield, Ms. Isaacson, Mr. Isaacson, we're getting far afield in the merits of the case. We're not going to get to the merits of the case because this court doesn't have jurisdiction. There's small claims court, there's district court, there's superior court. Each of them have different levels of jurisdiction, matters that they're allowed to discuss and make decisions on.
Your Honor, may I speak, please? Your Honor, may I speak?
You have been, while I've been trying to speak.
I haven't spoken up about attorneys. He's misrepresented the case, Your Honor. I've been listening on my bed, upstairs to the attorney. He's misrepresented the facts. He's misrepresented the actual law that represents the situation here, Your Honor. It's not RCW, whatever he claimed. And also, Your Honor, I want to say something about just proper decorum. This is not trial by ambush. You don't bring an RCW into a court and waylay some poor lady, my wife, who's not an attorney, without providing that to her so she can review the law and have a rebuttal that's appropriate. You don't do that. It's not proper.
I can see now why you're not an actual lawyer. And what do you even mean when you say that lawyers aren't supposed to cite court rules when they come to court? And stop acting like it's some attack on your poor, ignorant wife when it was you dumb folks that brought this case in the first place.
So I'm saying that you can't have an attorney in district court. One, you do have jurisdiction, Your Honor, and I can argue it very well if I can see the law. I can do it. You have jurisdiction. So what I would say is that if this attorney is able to sway the court and be persuasive, I would ask that this be continued so that I can go research the law, provide a proper rebuttal, because the reality of the property is this. The property literally is owned by the Olympia Yacht Club, and pursuant to their bylaws, we are allowed as an outside party, not a member of the Yacht Club yet, to make a purchase of such property, but only on approval of the Olympia Yacht Club board and their laws and bylaws. They are the party to this lawsuit. They got it. The whole argument of this lawsuit, Your Honor, is a breach of contract. The Olympia Board of Trustees got into a contract with me and my wife to purchase this property or sell it. We have all of that in our records. It's all in front of the court. The court has the jurisdiction to have a breach of contract claim, and also this court has jurisdiction to hear interference with contractual relations. Those are the issues before the court. The court we are arguing that the Olympia Yacht Club created this whole controversy, created this problem for us. We can show it by the facts, created a contract with us. We have all of the 4 prima facie elements for a breach of contract claim. They built a contract with us. Ed Stolaric was the representative of the board for the creation of that contract. He is the one who has standing to this court. We have proven standing. We've proven jurisdiction. The attorney is speaking over Mrs. Isaacson and not allowing her to properly argue this case as if she were an attorney. That is not fair, and it's not what this district court was designed to do. We know this. So I'm asking that if the court would kindly allow us to get a continuance so that I can put all of what I just said into a properly articulated document with the proper exhibits, I'll be happy to do that, Your Honor. But my God, I've got liver disease. I'm on the UNOS patient list. I'm about to, it's been a rough winter, Your Honor. I will do my best to put that all together, but frankly, don't dismiss the case. I'll get a days to respond to the attorney. You do have jurisdiction. He is not properly doing this. He is the attorney who mucked this all up in the beginning, just like Mrs. Isaacson said. This attorney, this little attorney, has acted, in my opinion, in bad faith, and we have documentation for that, Your Honor. Please do not dismiss this case as misrepresentations of what is jurisdiction and what are the facts of the case and what is the justiciable issues in this case and who has standing and who has the right to bring the case before this court and also to ask for this court for proper relief. And all of that is here in this court. You have it, Your Honor. I can bring it before you and I can argue it properly. Please do not dismiss.
All right,
this case.
Well, unfortunately for you, Kevin, all of your begging and pleading is for nothing because you and your infinitely limited knowledge didn't even serve the right legal entity to begin with. Now, this would normally be the point where I say, it's in your best interest to get a lawyer, but clearly the Isaacsons are already working with one of the best almost lawyers in Washington.
Mr. Isaacson, enough. I'm sorry that this is such a problem for you and it's upsetting you, but saying it over and over again doesn't make it so. What I'm finding is that Mr. Stolarik is not the proper defendant in this case. The Olympia Yacht Club is. He doesn't own the property. He doesn't make all the decisions. The Yacht Club and the board of directors or whatever make those decisions. He doesn't. So it's not properly served on him. That's number one. And number two, I have real question as to whether or not this court has jurisdiction over the property. You can argue all you want about that. You can look at the statute as well. The burden is on you as a plaintiff when you're filing this to understand those things when you bring them forward. In a small claims court, all Mr. Berner has done is raise two legal issues, nothing about the facts or the merits of the case. One is service, second is jurisdiction of the court. It's appropriate in this instance on behalf of the Olympia Yacht Club, which has been improperly served, but is aware of the case, obviously from what you've told me, that you've had discussions with him in the past, that's fine. The Yacht Club still has to be properly served in order to be held to account by a court, whether it's this court, district court, or superior court. What I'm telling you is this court doesn't have the jurisdiction to do that. Number two, number one being that Mr. Stolarik is not the proper defendant in this case. So I am going to dismiss this action. If you want to look at this further, Mr. Isaacson, and make your case, you can do that. But we're not going to continue this indefinitely. Apparently, this is the second effort at this case. Maybe the first had a problem with service. I don't know what the issue was there. I'm not looking into the merits of the case. I'm looking at the legal approaches to bringing this case in the first place. So
Okay, so
that's it. We're finished with this. Okay.
How are you dismissing it? With prejudice or without?
Without. If you want to refile, go ahead. But
Thank you,
Your Honor.
remember the issues that
We
Mr.
do, Your
Berner
Honor.
has pointed out.
You made them very clear to us. Thank you, Your Honor.
Thank you, Your
for
Honor.
kind consideration of this case today.
Thank you, Your Honor. I would just request that the Isaacsons return my calls or return my letters. I represent the Olympia Yacht Club, the represented party. They know that. They should contact me.
Your Honor,
Your Honor,
that's very deceptive.
All right, that's all. All he
Your
is
Honor, we
is
would like-
making a request. He doesn't need a
Why
response
are you
to that.
giving him time? We don't have time, Your Honor. That's very prejudicial to us.
Thank you, Your Honor.
Thank you.
Thank
Your
you.
Honor.
That's all.
Call our attorney, Joe Paneer. the court now knows who to call. I'm sorry, Your Honor. It's very upsetting to hear what has happened today. And the other attorney has been disingenuous to this court, and I have to put it on the record.
Well, I'd say he's being about as disingenuous as you're being stupid. The bottom line is, you misfiled your case and lost. So get over it. Learn the actual law and serve your new case on the proper party. And most importantly, dump the half lawyer for a real lawyer, if you think you can handle one. Alright guys, so that's the end of the video. If you liked the video, then hit the like button. If you disliked it, then hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.